Committee of Tynwald on Whistleblowing Policy Implementation. I'm Julia Chem, HK, and I chair this committee. With me today are Gary Clewett, MLC, and Anne Corlett, MHK. Please can we ensure that any mobile phones are on silent or switched off so that we do not have any interruptions. For the purposes of Hansard, I will be ensuring that only one person is speaking at any one time. So thank you for attending today, and for the record, could you please introduce yourself and the capacity in which you're appearing before the committee?
I am Debbie Holzall, and I am the Regional Officer of Unite the Union on the Isle of Man.
So in your submission to the committee, you state that staff making disclosures often face punishment instead of protection. That is the opposite to what the employment legislation is supposed to achieve. So why isn't that working?
So, what I'm going to focus on today is my evidence concerning a whistleblowing operates in practice once concerns are raised, and whether the current policy provides them real protections. So under the policy, concerns are raised internally and handled by managers, departments and HR. Investigations, decisions and outcome remain internal throughout. So there's no independent reporting route, there's no independent investigation and no guarantee of anonymity, and no independent review where protection is removed. In cases referenced in my evidence, disclosures were classified as not protected by internal decision, with no independent mechanism to challenge that decision. When this occurs, safeguards fall away and individuals are left exposed, which I have seen the fallout on many occasions. This evidence is about system design and impact and not individuals or intent. So the key statements in what we will be looking at: whistleblowing is managed internally from start to finish. That is unacceptable. Protection depends on internal classification with no independent review. Once protection is removed, safeguards fall away. Individuals are then managed through standard HR or disciplinary processes, and this shifts focus from the concern raised to the individual. HR is part of the employer and cannot be independent by design. I'm not alleging wrongdoing, I'm describing structural risk. A system that investigates itself cannot provide genuine protection, and as such it's marking its own homework. In some whistleblowing related cases, individuals cannot continue working as their employment ended through settlement agreements containing confidentiality clauses. The effect of these agreements was to prevent individuals from speaking out about their whistleblowing experience, removing transparency and organisational learning, which are then dumbed down from a whistleblowing to just a grievance, which is facilitated by HR. In some cases, representatives from the AG's chambers have attended meetings connected to handling or resolution of whistleblowing related employment matters. This highlights the power, imbalance and experience by individuals whose whistleblowing protection has fallen away. The issue before the committee is whether the whistleblowing system protects people who speak in the public interest. At present, whistleblowing remains an internal process from start to finish. Protection cannot be removed internally with no independent review. What then happens? People are left exposed. Under whistleblowing arrangements, until whistleblowing arrangements are independent, protected and trusted, they will not provide genuine protection. We are asking for an independent panel to review all whistleblowing. And I don't see why a trade union cannot sit within that independent panel.
Thank you. Also within your submission, you did state that departments are not held accountable for retaliation, poor management or mishandling disclosures. Isn't that what happens when whistleblowing cases actually reach the Equality and Employment Tribunal? But what do you feel, and you've just mentioned with regards to an independent panel, do you feel there is anything in your union's view that could make that position better? Or are you looking for, when you've made that comment within your submission, what exactly would you be looking for to address the non-accountability of departments, as you've stated?
There has to be an independent, external provider with trade unions sitting on there. How do we put trust and confidence in departments when the very person or the very officer who's been highlighted as a whistleblowing officer has no real understanding? They then go and seek advice from the Attorney General's office or HR. And with the greatest respect within HR, where's their qualification? And where is their remit? Because at the end of the day, I go back to the original what I said, the mark the home homework. There is no independent. They will dumb down a whistleblower to say it isn't, which then the fall away is the protection of a whistleblower. They are put back into a lion's den. That's what happens because it's incestuous. The behaviour, the nepotism and everything that runs through this. I stand, I watch, I see what happens and I see no accountability. And that's why you need independence on whistleblowing. The very fabric of what this policy is about is protection of departments. It is not the protection of the whistleblower, and that needs to stop.
Okay, thank you.
Can I just ask, I mean, you've got a huge amount of experience in this, and from talking to whistleblowers, what's your impression of the culture in government when faced with reports of health and safety failures or other protected disclosures?
So I have 20 plus years as a government employee. Prior to me doing this, and I was a representative. What I see, it's peaks and troughs. If you liked, you liked, and you'll be supported. If you're not, look out.
Thank you. And in your experience, is this sort of one culture right across government, or are there different approaches in the different agencies, departments, business areas?
We could take that in two ways, couldn't you? If you don't hear from a department as a trade union, you'd either say that they run very well and they have very supportive managers, or they're afraid to raise their heads above the parapet because of what would happen to them.
Okay.
Ms. Halsall, you recommend that there should be measures to change management culture to protect and not punish the whistleblowers. What sort of measures would you have in mind?
Independence, people who know, people who sit on a panel who understand what whistleblowing is, what's protected disclosures, and also for some consistency that a trade union representative sit on there to see that it's fair and it's reasonable and it's justable.
Since the last whistleblowing committee, which I think was 2021?
2019.
19 to 21. The legislation has been updated, I think, twice. An earlier version and then more recently, I think it was October last year. And have now introduced the public interest test, which never existed previously. Do you think this has been an improvement? Has it shown any improvement thus far?
Are you asking me, in my opinion, when I sit where I am as an officer, do I see any improvement? No, I don't. And I did go in front of the committee in 2019 as well. And from then, would you say there was positive changes? I would say more negative than it was positive. And in fact, I would say culture and behaviour has escalated.
So part and parcel of that previous select committee recommendations was the policy should be rewritten. I think we're on our second version of that rewrite. Do you think it would encourage people to report their concerns, and is it going to achieve the right forum for an individual once they whistleblow?
When you look at the paper, again, I've already stated what I feel about the policy in itself, and policy doesn't trump law, it's very clear that it should be protection. The island's very small. People talk, and people know that if they raise their head above the parapet, they are going to be subjected to very inappropriate behaviour, and they are going to be punished and pushed through a door, whether that be via an exit, with a possible non-disclosure and a dumb down that is not a protected disclosure, or they leave because their position is no longer tenable, because the very fabric of the people who they put the trust and confidence in have turned on them. That is what happens. That's the reality.
And when you say that that's the reality, and when you started in your conversation, you said that they start out as whistleblowing, but they then seem to get diverted into an employment matter. What detriment is being caused there? It's taken away that protection. Is that what you're saying, loud and clear?
And if you look, so your biggest part of your contract of employment is the unwritten part. It's implied terms. It's trust and confidence. What do people do? They put the faith and the trust under duty of care, code of civil service, whatever it is, to literally protect disclosures coming forward, to literally say, this is wrong, this is what's happening. What happens to them? Then there's somebody who possibly sits across the table who has no qualification and maybe have a desirable within a job description, who will literally say it doesn't meet the criteria. Then when you have to challenge that, you challenge that into their own department, who literally would be your chief officer. Decisions has been made there. They may take advice from the Attorney Generals, they may take advice from HR, 9 times 8, 10 it's HR. And not here to slate individual departments, but what I'm saying is it is all wrong, because what happens is the protected disclosures is then being deemed it's no longer that. So what happens to the psychological safety of the people who make the disclosures? It falls away. They are treated inappropriately. They will be suspended. They will be facing allegations of gross misconduct. They will be part and parcel of processes that is not warranted, because they no longer fit within this area, because they're problematic, they cause problems, we don't need them in. And yet all they were doing was in their best interest and under their duty of care, code of conduct, financial regulations, to raise the valid points they are raising, yet they are vilified. They are vilified to the extreme, and then it's dumbed down as no longer a whistleblowing, it's no longer protected disclosures. It's because you have challenged the system. Therefore, you will go via some agreement, some non-disclosure, and it's literally get rid. That is what happens. That is the reality. While sitting in this office as the officer of Unite the Union on the island and the largest trade union, we have seen the pattern increase, because you have no understanding of what protected disclosures are, and you were talking to people who have no qualification or understanding, and if they don't, they're not taking the appropriate advice. That's where we become involved. We have now become HR, staff welfare, we are advisors, we are everything rolled up, social workers, because they've got no safe space. They haven't got it in their workplace, and the place they come is the union. And we are the only people who stand and fight for these people, and they have rights, and they are taken from them time and time again from the biggest employer on this island, and that is absolutely shameful.
One of the things that troubles me is that when you look at it statutorily, whistleblowing should be a cut and dried thing. There are certain things in terms of protected disclosures to do with health and safety, to do with illegal things that are illegal, taking bribes, paying bribes. I mean, there is a fairly short list of things that fall into whistleblowing. And what does concern me is and a lot of them seem very black and white, how do they then suddenly become not protected disclosures, when by the very nature of some of these things they are. I mean, they clearly are. So I'm not saying you're wrong. What I'm saying is what I'm trying to understand is where in the process, what is it failing? And it may well be because people don't, officers, whatever, don't understand, they haven't been trained, we just spent yesterday in a whole thing on with the legal things on what are protected disclosures and how to deal with them and things. So that to me is very important, because I've always looked at, I don't know an awful lot about this in terms of whistleblowing, but I've always looked at it in the past as well, it's fairly cut and dried. You know, there are these things. If you meet these thresholds, it's clearly whistleblowing, and whether there are other employment issues with the individual, that's irrelevant. That's a separate issue. But whistleblowing is whistleblowing, and what we're hearing is it's not.
And with the greatest respect, Gary, you're talking with somebody who basically is fully compos mentis. With the greatest respect, you're not always talking to somebody who has their finger on their pulse. So therefore, their interpretation.
And that is the issue, is the interpretation. Yeah.
But you sit there and you would expect when you go in with a protected disclosure to somebody who is highlighted as the protected officer, that they have insight, they're qualified, and they understand what protected disclosures are. That's in the real world.
You get the impression it's circling the wagons. It's basically protecting the department, protecting the officers. Is the prime objective.
With the greatest respect, it says Bovril on the side of the bus doesn't mean you get on and get a cup, does it?
Just ask you, Debbie, do you feel there's a clear line between what is whistleblowing and what is an employment issue?
Yeah, of course there is. You know, your day-to-day runnings of, you know, if you've unfairly treated at work, there's a fairness at work policy. If there's a grievance because they haven't followed, you would follow the grievance procedures. They're very clear. You know, there should be no muddying of water. It's very clear. And if they come and they ask for advice, we advise them accordingly. But I think that's where, you know, you sit there and people will say, well, what's your experience, or how you've got here, you've got skills, you've got knowledge, you've got qualification. Can you say about that, the same person who you're sitting and you're making protected disclosures and you're very vulnerable? You're worn down and you're hit time and time again. You're going for a safe place, psychological safety. You're going to somebody who you trust with trust and confidence that these are my employer, they will do the right thing. Do they always do it? No, they don't. They don't. And that's the shameful. We're not in the 1900s, you know, we are supposed to be looking here and what our services are providing and future-proofing what that looks like and protecting your staff, because without your frontline worker you've got no one. And you can have as many senior level managers sitting up here, but I would ask some, have they got common sense approach? Probably not. Probably not.
I think in the evidence you sent in, you said that the policy is purely procedural, and that it provides no actual protection. So, kind of my question is, why isn't the protection of the law enough, and what's needed to provide that protection?
So we go back again, fundamentally, to the implied terms of your contract as trust and confidence. You go through mandatory training about what's right and what's wrong, financial regulations, etc. Yeah, policies and procedures do not trump law, but you give your trust and confidence to your employer. And you will go to your employer and say, this is wrong, I'm highlighting this, what do we do? If there's financial irregularities or whatever, as somebody's come to harm, if the safeguard, we hear about safeguarding policies, we hear about all these different things. Where's the safeguards for the whistleblower? Where are they? It's a bit, as I made my comment earlier, you're marking your own homework. So how can you expect to go into a meeting for the same very people who's going to tell you that's not whistleblowing, it doesn't meet the parameter? I'd go back and ask the question is, what is your qualification to make them determinations? You know, you have to have a moral compass and a social justice, and it is not happening. That is what I see. I see the fallout. I see people who are broken. That's what I see in a system that's broken. So why would we sit there and say that's an appropriate policy? Yes, law is here, policy is here. Who do the safeguard? The organisation. That's what they do. The safeguard an organisation, because what then becomes the problem is the person who whistleblew, they're out that door. It's as simple as that. They are treated inappropriately. And I'm not here to talk about individuals, because if I was, I'd be sitting in here for 1 week at least. What I'm saying is the policy is not fit for purpose. And there needs to be independence that sits outside of that. And if they want to basically build good industrial relations, they will have the trade unions sitting in there as well. Because we will always, this union will always challenge. Always. It is ethically wrong what they are doing to people.
And you recommend a centralised register of whistleblowing disclosures and the outcomes. Are you satisfied with the progress that's being made on that? Is there any progress being made on that?
I was just about to say, could you tell me what that progress is?
So the recent policy that's just been implemented introduced a new internal process of everything going into central OHR, which was it's been introduced by the PSC in the November 25 policy.
Okay.
You're saying that hasn't been tried and tested yet, but do you think it's right to do that for employees to have to go into OHR? Because in your submission you stated that about the structural weaknesses in OHR, so could you expand on that?
Again, my terminology is, marking their own homework. If you want to build trust and confidence, and lessons should be learned. We hear that quite often. Lessons should be learned. Should have learned that lesson when the biggest tribunal case on whistleblowing came and resulted in the taxpayer paying a hell of a lot of money, and then there was a review from then. So when you go to HR, your understanding is there's going to be some support measures put in place for you. Safeguards, psychological safety. There's going to be basis of this is what you need to do, this is what we're going to do. If that means lift and shift somebody out of an untenable position and redeploy them under PSC for something, let's just protect them anyway. That doesn't happen. There's nothing that I see or nothing I hear that will convince me at this moment in time that they are putting the right structures in place for the people. They are protecting themselves with an internal policy, dumbing down what whistleblowing meets in a criteria, and saying it's no longer that. Again, I have to go back to say that them safeguards then fall away from people. And once they become vulnerable and exposed, that's when the problem starts. I probably didn't answer your question, Julie, but...
No, that's fine. So the public service integrity line was something that was introduced to try and bring a level of independence following the last committee recommendation. Are you aware of any of your members making use of that, and was it in accordance with the policy that it was reported correctly and action was taken?
Okay, so integrity line is run by Crime Stoppers or whatever. You can do it. You can do that anonymously. And it then gets signposted into 3 areas. If it's financial, goes to financial. Either Manx Industrial Relations or OHR. So, no trust and confidence. So it's going back to the very same people you possibly have a whistleblown on. So tell me what's tangible about that. It's nothing. So has our members gone via integrity line? Yes, they have. Has any actions come from it? No, it hasn't, because again, it can be under anonymity. And if somebody with the greatest respect come to me and said, your member's under investigation for blah, 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 and there's no name to them, I'm going to politely tell them to go away. That's what I'm going to do. So tell me what is tangible, what has happened since the integrity line was implemented that has come out as a positive. Because I don't know any, and I'd be absolutely amazed to hear what that is.
So how do you think what do you think on the island, and we are small and we all know an awful lot of people, what do you think could work?
I'm not here to ask for heads on sticks, am I? That will be inappropriate. As I said, I'll go back to there has to be the independence. Sorry. There has to be an independence, and there has to be some structure in there, and the trade unions need to be part of that. If they want to build trust and confidence, and I am fully endorsed and fully obliging of good industrial relations, because that's what we have across departments. But what you need is the independence to scrutinise, to make sure everything is basically above board and people are being protected, as well as an organisation, as well as a department. But the fundamental person who is not being protected, that's all protected here, is this person, very vulnerable, just left. We just leave you, because who have you got? So if you're not in a trade union, who have you got? You've got no one. Unless you go, whether that's via MHKs, you know, staff welfare. People's hands are tied, and I don't think people understand. We talk, again, lessons learnt. Biggest case, it hit the world about what happened. What have we done since then? What has been tangible since then that has changed? You asked a question very early on, is, have I seen change? Have I seen change in a positive way? No. Have I seen change in a negative way? Absolutely. Has it ramped up? Yes, it has. What is the changes? As I said, I can't tell you that individual, it's not about individual. Your policy is clear. It protects the departments. It protects an organisation. It does not protect individuals, and that needs to change. So I'm asking the committee, you need to seriously think independence, it sits outside, and stop letting them mark their own homework, because you will get departments come to sit in front of you and they will speak to you. But what you need to remember is fundamentally they are employees of the Isle of Man government. They're not going to go against their employee unless the whistleblower, and we all know what happens then.
So when you're hearing responses to say political questions in Tynwald or the House of Keys, and we're told there's very few people are whistleblowing, we're told there's very few people contacting the public integrity line, that's because of trust in the system, or is it because, as you said earlier, they're not being reported accordingly so that ministers, chief ministers, can give the right answer to the Parliament? So, for instance, I think it was reported recently, it's certainly been debated in our Parliament, we were advised there was only one whistleblower.
I'll just say they're being very disingenuous. That's the word I'll use.
You know, there's been, at least in the last 5 or 6 years, three different attempts to come up with new whistleblowing policies that sort of things. Despite all that, why would you attribute, why do you think it's going downhill in terms of it's more pervasive, it's a bigger problem now than it was 5 or 6 years ago, which is kind of what I'm hearing you saying. Okay. But I'm trying, why? What's changed inside government?
So, you know, I often get asked questions about, so I'll use this terminology, why does a bully bully? Because they can. It's as simple as that, because they can. And it's enabled, and it's supported, and the mechanisms is not there for the people who need it. That's what happens.
When you say it's enabled and supported, by who?
Well, it's facilitated by the advisors that they take the advice from very departments again. I have to go back to exactly that.
And in your experience, when the departments have tried to deal with it themselves, are they seeking advice too late from the Attorney Generals?
That I can't comment on, because I have no idea. But if they take advice, you know, some of the advice, and with the greatest respect, I'm not here to slam departments, it's very inept.
So, in terms of understanding the whistleblowing policy, I mean, as I said, there have been several, and there's ongoing CPD sessions for politicians on whistleblowing and what are protected disclosures and various things like that. And my understanding is that certainly the officers, and one would certainly hope and expect that all designated officers have been through an intense CPD or other forms of training in terms of what whistleblowing is and what protected disclosures are and aren't. Can you comment on the level of communication about their rights, responsibilities, policies and things that are imparted to your members, to the employees? Are most of them aware of what their rights are, what the policies actually are?
People go to work. They go to work to do a good job. Nobody goes to work to do a bad job. People don't involve themselves in a policy and procedure or terms and conditions unless they need them, and that's when they refer to them. Is there education? This is more than education. Should I ask the question as well, Gary, is who's the one who facilitates the education? And a chief officer will only be as good as what their officers make them. It's a bit like squirrel with nuts, isn't it? My information, you're not getting any more. So I'm not saying here that a chief officer may not know. But what happens, I would also say is, if you raise and protected disclosures and they highlight the chief officer as who's the person you go to, but they are part of the problem, who do you go to then?
So you've identified that there is a gap that chief officers, there's no process for. From what level up? Chief officer and CEO? Or
depends what department, doesn't it? I don't know. You know what?
But it's really helpful, because that's what we're discussing, is whether the policy and procedure is appropriate. So.
And my concern again is when you look at that policy, or that, you know, that new procedure, that new policy is literally, if you've got a problem, you go to the chief officer. But what happens if they are the problem? I'm not saying they are, but that's your scenarios. You work on your worst case scenario is, where is your next avenue? Don't say an integrity line, because it doesn't mean anything. It just signposts you back into government.
So can I ask, did your union did you take part in the implementation and the review of the previous policy? I think it was 22. And this recent policy, did it go to your union to be ratified and signed off as acceptable?
So we have a TUREC, which is a trade union recognition agreement with the PSC, along with the sister trade union. When we raised the concerns about this new whistleblowing policy, we were just told, oh, it's just a tweak because it's a change for the law, and that was it.
And do you believe it was just a tweak, now that you've in full receipt of it?
Again, if they told me it was written, I'd go and check.
So is that a failure in the process for?
I think when you look at
the
a trade union recognition agreement, is literally we work in partnership. Again, I'm not going to rubbish the individual, the people who I work alongside, because we have very good industrial relations. But what I'm saying is there is failures within that. We highlight them and nothing seems to be addressed.
So since the new policy's come out, you've made representation back into the PSC?
Yeah.
Okay. And then with regards to when you're actually advising whistleblowers, do you think that there is actually, and I think you've probably answered little bits of this, but in your submission about the capability of the public bodies to actually address, resolve health and safety issues or any other relevant failures, and is the leadership and qualification of individuals who perhaps are classified as the whistleblowing officer, have they got the right skill set to support the public body in dealing with the whistleblowing complaint once it hits their desk?
You can produce a document and say, I've got these qualifications and I've got this, this and this. Has somebody got common sense approach? No. So it doesn't make a difference. You know, I have degrees, I have qualifications, but have I got common sense? Yeah. Do I know what's ethically right? Yes, I do. But that's why you're talking difference. And that's why we're all not the same. Somebody has moral compass. Somebody is fully compass mentis. Somebody is off and as mad as a box of frogs. You don't know who you're sitting with. This is the trouble. What you see and what you're doing is protecting the person, because it's not about me. It's not about my personality. It's not about anything that I'm there other than to protect the person who has come to me in desperation. And people need to remember, when somebody comes to a trade union door and they walk through that door, is because they're desperate. Because they need support, they need the mechanisms that has been failed by their employer. That's what they're looking for. We get your daily phone calls of just, what's this process? Can I do this? Can I do? That's the run of the mill. That's what happens with trade unions. When somebody walks through the door who's in desperation, that's when that kicks in. That's when we start speaking to people who we say, we have got concerns. We've got concerns. I've walked the street with people who have been on the edge of taking their life. That's how impactful this has happened to them, and yet it is not acceptable anymore, but it is by the employer, and that's different. That's where it sits. It is not acceptable anymore. We are not going back. We should have made changes. There should have been positive changes from that tribunal. And I don't see anything that has been a positive. In anything I've seen a negative, and I want to understand. So what was on the basis of when that happened and the biggest award in tribunal was set, what changes had happened? What changes had happened? How in-depth was that training given to departments? What and who provided and facilitated that training? What qualification did they have? What did they see as safeguards, signposting people into different areas? People talk mental well-being. You know, we need to talk about this. Let's talk about psychological safety. They've got none. They've got it with this union. That's what they've got, and that's where I move forward. I will not be silenced by anyone, and I will stand where I need to stand, representing the members until I'm blue in the face, and I'm going nowhere.
So with regards to non-disclosure agreements, you mentioned it quite early on, and you felt that compromise settlements for an employer that brings a concern forward. In that, what have you been in that process? Can you explain that process? Can you sort of give us an understanding as the committee what happens in that process? And, you know, does it start out as
So somebody
we want to pay you off, or does it start out we want you to keep your job?
Usually is, do they want a settlement? That's usually one of the questions that's asked fundamentally straight away. Do they want a settlement? Do they want to
And
go?
is that, sorry to interrupt, is that in an environment of just the union and the department, or is MERS involved at that point?
No, MERS is not involved. Okay. And it could be a without prejudice conversation. Because what we would do would be... So that could be starting out as a whistleblower. People are basically then, you know, constantly put under pressure that it's no longer a whistleblower. You didn't make protected disclosures, but you obviously could see you're not happy in work, so therefore would you be willing to take a settlement, and we'll just basically facilitate that with a non-disclosure. Because irrespective of non-disclosures, if you whistleblow, that still doesn't stop. That still sits here, it's still law. It's law that you have made under that right, protected disclosure. What they do is they dumb down that ability to see it. That's a protected disclosure, because what you're doing is you're signing an agreement which is wrapped up in a non-disclosure that you won't rubbish the department or employer, and they won't do that. It's a vice versa. But you are then basically tied to something that no longer sits in the parameters of a whistleblowing. And it'll be a sum of money.
The issue with, regardless of whether you sign an NDA or protected a settlement agreement or not, I mean, if you do, and I think we're fairly clear what a protected disclosure is. Now, just because somebody decided, whether it's OHR or a department, the AGC's office decided that, well, we don't think that's a protected disclosure. To my mind, protected disclosures are fairly black and white at law. And that under the law, there is absolutely no way that a non-disclosure agreement or a settlement agreement can prohibit you from getting up and talking about your whistleblowing part of it. That's the one thing they cannot. The financial settlements, all the other things, absolutely, that could, you know, this is none of my business what anybody is settled for. But the essence of the whistleblowing, the protected disclosure, just because somebody says it does, it's not that. There are tests that you can apply, and if it is that, it's whistleblowing regardless of what the NDA says, and therefore the person can speak about it publicly. So, and again, I know we're dealing with people who are not, you know, employees. They don't have the legal background. They don't have the money to go to get legal advice.
Well, with this union, we give legal advice and we give legal representation. So we go through them processes. But we would not be advising somebody to do a non-disclosure if they had a case in whistleblowing, because we would our full backing would be behind them anyway. They meet the parameter. It's whistleblowing. They will be supported legally and by me.
And compromise agreements and settlement agreements with and you know, you're not allowed to speak out.
Yeah.
What's that? Is it a legal document saying?
Yes. Signature by both department and
employer. Is it time bound?
The non-disclosure, you have to have a look at what that specifically says.
So each one could be
Different.
And have you witnessed many?
Mm-hmm. Quite a few. Yeah.
Yes, certainly.
Debbie, you mentioned a number of times about a panel,
Mm-hmm.
and you mentioned that you think that the unions should be on the panel,
Yeah.
or at least your union should be on the panel. Who else would you envisage being on the panel, and what would the panel do apart from hearing from people?
Well, they would scrutinise departments and hold them accountable. I'd chair it, if that's what you're asking, Jonathan. Not a problem. I would chair it. No, I'm saying not just this union. What I'm saying is you want a partnership working agreement of people who have qualifications and understanding. That's what you need. And you also have the ability, it's a bit like a risk matrix, you know, your green, your amber and your red. You would sit, basically, where does that sit? You would have somebody who would scrutinise departments and decisions, and whether that would sitting in an amber, or was that green, and that was an acceptable position, and there was reason and rationale why we got to this position.
Okay.
Your antecedents, your behaviour and your conclusion. So where do you start and where do you end up? Because one of the things you don't want to end up is in the red.
Okay, so it scrutinises departments. Is this a panel which is like a board of auditors which looks in after the event, or is it a panel that
No.
vulnerable person, as a whistleblower, goes to the panel,
Goes to the panel.
and then what's the panel? Is the panel then going to instruct the department to deal with the safety issue? Or what? I don't quite follow.
Accountability, responsibility, and the fact is, I mean, you can ask me what I think, you know, on my wish list. I will give you my wish list of what I think should happen. But you know what? You employ a lot of people on movie star wages to be doing a job that they're not doing. So I'm quite happy to sit there and say, this is what should happen. And I've already submitted my paperwork of what it looks like. I've already given you my opening statement. But if you want to give, if you want me to give the varies of what they should be doing, absolutely, yes, I will. I'll produce a document, a business case of what that looks like. But you can't sit there and say it's an acceptable position now for each department to make decisions without them being scrutinised. And why does it sit with a department? Again, a bit like marking your own homework. If somebody comes with an issue and it's a whistleblowing and it meets them parameters, they go to this level. That's where they go, because if they sit within the confines of the department, you can bet your bottom dollar something is going to be happening to them, and not the accountability and responsibility held on a department. That's what's going to happen.
Debbie, I'm hearing you call for independence loud and clear. So if an independent body were set up, are the policies, procedures, legislation that are in place now sufficient, or would they need to change?
Your policies and procedures will never trump law. I think what you need to do is you're looking at what is now and what is moving forward. So you're future-proofing. It's a bit like, you know, your matrix, you risk assess every single day on certain things, from opening your eyes to getting out of bed to whatever you do. And there has to be an overarching look all the time. It's moving targets. You know, it's fluid. It moves forward. Law takes forever and a day to change. We know that. But if you're working in the best interests and you're doing the right thing for the employee, and your policies and procedures are moving forward with caveats attached, is this is what it is, but moving forward laws could change, blah, 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 blah. That's what you're asking for.
Thank you.
If we were to set up an independent panel, ombudsman, whatever, if it did one thing, and that was to determine at an early on whether something is a protected disclosure or not, would that not address some of the problem?
No?
Why not?
Why would it?
Well, because surely at that point, then you can't have the department or anybody else coming in and saying, well, that's not a protected disclosure. It has been independently reviewed. It is a protected disclosure. And, you know, at that point, you hope things do fall into place because it's no longer in dispute. That's my one point. The other point is, if we did set up an independent thing, I can quite imagine government saying, well, if the trade unions are going to be represented, then OHR has to be represented too. Or would we be better off having an entirely independent of anybody? In other words, whatever that might be, but no employee representative, no employer representative, but basically an independent tribunal that would look at these matters without,
So why would you say, so trade unions sit here, why would it then be OHR representative?
I don't know. I'm just speculating what the position might be.
What you want is, you want
an independent body.
Yes, and also build trust and confidence. You're building trust and confidence with your employees. You are ready at this moment in time for a retirement bubble. People are ready to retire. At one time, it was you were a government employee and you were proud of that fact. Not so much now. Not so much now. And that's why I'm saying you can only get better. You can't take retrospective steps back to what was in the days of the Victorian ages or whatever. We sit with the greatest respect in front of yous, and I'm sitting saying the things that were addressed. In the ransom case, what has happened since escalation? Improvement? Protections? And then in the meantime, policy changes. So we've got these new policies which we're going to safeguard the individual. Oh, let me think. No, we won't. So with the greatest of respect, Gary, you can put whatever you want in place, but if you want to sing from the same song sheet as a trade union, you will have us at the basis and the inception of anything. We are not there to just challenge, we are there to work in partnership. But we are there, and I facilitate, my role and responsibility is to facilitate the voice of the members. They come to me, people will hear me, and they can make whatever assumption they have of me, because again, as I said before, I'm not going anywhere.
So at one point in your contribution today, you talked about nepotism, cronyism, and people that are appointed to roles. When you've been supporting whistleblowers, and obviously the outcome from the sounds of it, the majority are not given protection or into another role whilst everything's investigated. Is anything investigated correctly? And have you seen any... So the word perpetrators always comes in with whistleblowers. Have you seen any actions taken against the whistleblower that an individual that supported the view that you've implied today is that it's all protection, protection, protection? Do you see any of those people then being promoted or anything like that within the process? During the process as well?
Yeah. I see people being moved sideways rather than address the problem and the issues of that inappropriate behaviour and heavy-handed approach. They get moved into a different department because they'll be needed in there. No job, no advert, but we'll just sidestep. We'll lift and shift and we'll put them somewhere else.
But that doesn't happen to the
everything calms down. Yeah, that's what I see.
I think that the issue really comes down to human nature, in that we can put all the policies and procedures and things in place, but fundamentally it still comes down to, I think as you said, the individuals involved in adjudicating the cases, or the designated officer and things, whether they're of a mind to
follow policy and procedure.
Follow the policy to the letter, or to protect the department.
And you could say that's conscious or unconscious bias, couldn't you? You could literally say that, yeah.
It could be both.
And you can also say that people will go out via, and it's a constant. People will take their personality rather than professional judgments. So the code of conduct is very clear for a civil servant, and I see that being breached daily. I see inappropriate comments being made in meetings. They are being I then will correct them, and I'm told, oh, you're an aggressive union. No such thing. No such thing. I just don't think it's an appropriate behaviour because nobody challenges that.
Yeah. I mean, I can certainly see a situation where you're the designated officer, but to some extent, somebody comes to you with a serious whistleblowing thing. Well, if you take that on, you'll almost become an accomplice. You might not be, it might not be viewed very well by someone above you. So
role and responsibility, is it?
Yeah.
So if there was any action today that you felt should happen, one of the things I just spoke to the clerk about, Tynwald does have standing committees that actually scrutinise departments, but they're all in different types of committee. Would there be trust if there was a standing committee of Tynwald for whistleblowers to go to? Do you think that would build trust?
No.
Thank you. Have you anything else? No. Is there anything else you'd like to say before we close this public session?
No. Thank you for your time.
Thank you.
And if there's any further comments or you need to ask me anything, I'm more than willing to come back.
Okay, thank you very much. With
Thank
that,
you.
we'll close
Thanks
this
for your time.
public sitting.
The next one's 22, isn't it? Oh,
Okay, welcome to the second public session of the Select Committee on Tynwald Whistleblowing today. I'm Julie Edge, the Chair. With me today I have Gary Clewett, MLC, and Anne Corlett, MHK. I'm sure your mobile phones will be off before we start the session, but we welcome the Learned Attorney General and also Mr. Philip Farrer, who's the solicitor from the Attorney General's office. So welcome. So thank you for your submission. Would you like to just give a brief introduction, Mr. Farrer, with regards to what your role is within the solicitor's office, the Attorney General's office?
I'm a
General's
solicitor. I provide legal advice principally about public law and employment matters.
So you're specialising in employment?
Well, it's mainly around employment, but public law also.
Okay, thank you. So thank you very much for the submission and question to Mr. Farrer again. From your perspective and experience of the island's legislation on whistleblowing, is it as good as it could be?
I don't think any legislation is as good as it can be, but the recent changes were only implemented a few months ago, so it's too early to say what effect they will have. It principally implemented what happened in the UK some years ago by removing the good faith test, but instituting a public interest test. That public interest test it's not something you can say. It's not a formula. You suggested earlier, Mr. Cluett, that things are black and white. That certainly is not. It depends on the circumstances, and generally it would be suggested that, for instance, you've been focusing on the public sector. That matters in the public sector would probably have a greater public interest. You might have the same issue in a private contract environment, and it might not meet the public sector test, public interest test, but it perhaps would in at least certain public sectors. So it's unlikely to limit the number of qualifying whistleblowing cases in the public sector, but it has removed the issue of looking at motive generally, although it doesn't remove the underlying thing that, although it's not a test of accuracy, you don't have to be correct in a whistleblowing, you have to have a reasonable belief. So there's always an issue of the foundation for that belief and whether there's any justification. So it's not just every issue raised has to be seen as labelled or seen as a whistleblowing. It depends on the circumstances. Unfortunately, they're very varied. And I think it's also fair to say that one has to remember that we talk about whistleblowing, people raising complaints. It's not about a complaint. It's about providing information. And when I do my lecturing on this, I can come in and say that ladder's unsafe. That is not a whistleblowing. That's not a protected disclosure. That ladder's unsafe because the third rung's missing or woodwormed or something. That's a banal example, but you have to convey information. And in many cases, people are, I don't think there's any way of curing that. The government gives protection to people who raise matters which are seen to meet a certain mark, but you have to convey information. So, and public opinion, matters of political statement, matters of public debate, even though they may be contentious, are not easily protected disclosure unless you convey information within them. And that is the difficulty that I think you're right at one level, Mr. Cluett. Is that a legal breach? When somebody says that person's a murderer or there's a murder being committed, very easy. That offends against the such and such regulations from 2003, the meat packing regulations concerning pork products. And again, I'm being a little flippant. For example, you need to be more specific as to why something is a legal breach for it to meet that mark. So I've given you a few examples of the practical interface between legal protection and how it works is difficult. Could that be improved? I'm sure very clever people can say it can be, but how it addresses the flexibility and the nuance of what is termed whistleblowing is very tricky indeed.
So from your role and providing advice to various areas of government, what's your impression of the culture in government when they do receive a whistleblowing protected?
I can't give information to this committee about the cases I've dealt with.
No, I'm asking you generally, what's your perception of how the individual who's thought they've whistleblown, they've thought they've done it in the public interest, and it's health and safety or another serious area of government, do you feel that it's dealt...
They're all... They have to meet the mark. So a
So
legal obligation can be a very broad church indeed, and notwithstanding what it says in the policy, it can be about your own contractual circumstances and about your own experience. So,
do you think the policy that's been produced in November 2025 matches the law? Supports the law?
It certainly reflects what the law provides for.
Could it be improved?
I think all documents can improve. That one is not unique in that.
Do you think some cases actually get to be your advice being requested? I suppose I'll put this to the learned attorney. Do you feel that a case will come to you too late, and perhaps you could have... the previous whistleblowing committee, we had the former late John Quinn in front of us, and he always said everything reaches us too late. If we got in a bit earlier, that we could make a difference to the individual and to the way the department handles things. Do you think there's been improvement there?
I can't say what was prior, because I wasn't here.
I think just in the last Tynwald sitting, I said something similar. In a sense, by the time a whistleblowing complaint case reaches chambers, lines have been drawn. Ideally, no whistleblowing complaint would go as far as chambers, but by then there's a certain entrenchment. And yes, I am aware of what my predecessor said, but I'm not one to assume that in saying that he was suggesting that chambers should be shipped in as soon as a whistleblowing complaint is made. I don't think that's our role.
Can I just draw one distinction? I think it's in the paper, but I think it may need to be reiterated. Are we talking about here a whistleblowing complaint? I complain that I have suffered a detriment because I raised something I believe to be a whistleblowing matter, or is it I've raised an issue with the Attorney General about the level of light in the offices which infringes against some regulations, which could be a protected disclosure? There is a big difference. The Attorney General's chambers tends to be instructed that matters are more about the latter than the former. They are more about the later issues, about people complaining. And by then, I think as the paper reflects, matters often become overlain by what are employment disputes. And it may, I'm sure it's no surprise, sometimes you have more than one opinion about matters being raised. You have conflicting opinions. Sometimes there is more than one whistleblower in that sense, or potential whistleblower, and the employer, the body, and it depends on what the nature of the matters raised are. But if you're, I don't know, I'm going on the plane this afternoon. If you're at the airport, you could raise an issue about I'm an employee at the airport. You could raise an issue about your employment contract, about the cleaning standards, about the air traffic control standards, about the car parking. It could be a number of things. So the issue, the first and primary matter, is that the body should address the provision of information and deal with it. And at that stage, and I would suggest that overwhelming majority are dealt with in that way. People raise matters which could be qualifying disclosures every day in the nature of their work. And they're not classified in that way. Nobody thinks about it. That ladder's unsafe, or we'll fix it, we take it away, we'll make sure it's not used. There's not a form, there's not a label. What happens is when somebody says, I raised a complaint about that ladder, and then my manager or the foreman made my life a misery because he was embarrassed, or because such and such found out, or whatever. That tends to be the issue. So, and the law has to deal with that gamut And I think what some of the comments I've seen and heard are people are looking at refereeing the whistleblowing disclosure, if it is such, about whether it's valid or right or what action should be taken. Well, that could be about a multitude of issues. It could be about legal matters. It could be about how is that done in the realm of criminal law and current investigations.
And is it right that that starting point is done internally? We've just heard from the Unite Union. But the suggestion there is that those referrals would be better going to an independent panel. What, would you be against that?
I come back to my distinction. What are we talking about? Are we talking about my observation about the ladder, or my complaint that I suffered as a consequence?
I think, I realise my statement was very simplistic about the black and white business.
Some of them are.
Some of it is.
Oh, yeah, cool.
And clearly there's an awful lot of cases that are very, very grey. The issue, though, is, and I thought, well, maybe if you had an independent that could look at it, could test the evidence and things to determine whether it is a protected disclosure.
Which stage, sir?
Fairly early, I would think. But the issue is, if it is, and I agree that in many cases it is very, very difficult to determine whether something passed the threshold because it needs lots of evidence and these things like that. How then is the designated officer able to make that determination on their own?
By that, I think you must be referring to the government whistleblowing policy provision.
Yes.
That's a policy about what happens only in relation to public sector workers. Mm-hmm. So that's the first observation. It's about the law.
Yeah.
This is only guidance in one arena.
Right.
I think it's unclear. I come back to my example. If the person raises something banal and it's dealt with, you don't need somebody to tell you what it was. Probably never think about it that way. What this tends to be, cases where folk either have raised something and they feel it hasn't been dealt with, or they feel that they have suffered, or both. So there is something more developed at that stage. It's the obligation of the employer legally to meet its own requirements, or the requirements, obligations imposed upon them. You can have, of course, more than one employer in these circumstances, which complicates matters. I find it difficult to contemplate what stage that would come in, what legal powers they would have, and whether it would in fact be, I don't use the word panacea deliberately, but be how much it would cure in those circumstances where there could be a number of opinions. As I say, the technical nature of some of the issues of, that's unsafe, even whether it's a criminal matter, criminal obligation, not a huge debate. Cases can take a great deal of time and a lot of energy expended on debating something. And very often employers don't have the wherewithal to deal with some of those. So if a matter's raised and it's within the purview of that department or employer to make a decision, and it makes it, then you have, that can go further. I suppose you can always go up the chain about, oh, that was the wrong decision, I was right, we are being dangerous, we are being wrong, those sorts of things. That's in one facet. But the other one about, and I've suffered as a consequence, that inevitably becomes an employment dispute. And people are at loggerheads quite quickly in these matters, and you rarely find that they are simple binary cases. They're usually overlain by other matters, including people saying, I was a whistleblower, that's why I'm being treated badly. But you find out that some of the things that were raised were after a course of conduct had started. So you have to unravel, the lawyer's world, I'm afraid, is the causation of all of that. And that's very tricky indeed. We may have started off in questions, which all I've done is say it's complicated. But inevitably it is. the role of back to the role of a designated manager, a lot of these things happen after the second category, the disputes, and people are locked in to that row, for want of a better term. And the role of an independent designated manager, which this report seems to contemplate, is very unclear, because it can't come in. If you were the manager who'd made a decision, does it come in and say, Mr. Clewitt got that wrong? Mr. Clewitt, he was wrong about that. Yeah. Well, you may have a very different interpretation. As I say, some of these matters are very technical, or it may be it was a balance decision, or it was a resources decision. So this policy may help when people think, I need somewhere to go if I'm not being listened to and things are in danger. The ones I have experience of very rarely inhabit that. I haven't seen one, to be honest, but I haven't been here many years. They tend to be about employment disputes, and they tend to be vexed and intractable, and often done very investigations, what's the status of that, the qualifications, and it's done after the fact. And the legislation, which is consistent with the UK, requires you to make a complaint to the tribunal within 3 months. So very often they're underway. But the complaint to the tribunal can only be about detriment. It's not about whether the ladder's safe. In fact, the ladder needn't. I could have been truly believed it. Mr. Warrenborough didn't believe it. We have a disagreement, but it mushrooms into something else. It doesn't actually matter whether I was right, as long as I had a reasonable basis for believing it.
So from my experience, speaking on the previous committee and speaking and hearing from various whistleblowers, all they ever want to do is for what they've raised as a whistleblower to be put right. And it seems to go off direction then. Do you genuinely feel that departments have the skills to be able to deal with a whistleblowing complaint that comes to once it's... Do they understand what a qualifying disclosure is? So if somebody does go in with the ladder and says, I'm raising this today, and they're concerned, the individual themselves may not know what's happened because the ladder's disappeared. Their job and career are disappearing down a different route. So there's clearly something of a misunderstanding somewhere, and that's what we're aiming to do, because many people are concerned that the policy tells them to do this. You've mentioned the 3 months and their qualifying period to go to tribunal. There's lots of complaints to say the processes internally slow it all down so that they cannot go to tribunal. So, but you're saying you don't witness...
The policy does not prevent people issuing proceedings.
No, so what I'm saying is, whistleblowing comes forward today. They then have to gather information, because you said it is all about what information and what the complaint is. But there's no timelines within that to protect...
I must clarify something. To be a whistleblower, you have to have already provided the information.
Yes, but then there will be other information that gets gathered through investigation or whatever. So, which there is, that seems to be the process that happens. Somebody whistleblows, and then there's possibly investigations go on and more information.
Yes.
But the whistleblower, and many have, and this has been raised, they go out of time because of the internal process. So, but you're saying that...
Sorry, it's a fundamental misunderstanding. If I raise a complaint that something has been done improperly, a wrong in that legal sense, and I thereafter don't think it's been addressed properly and continue to pursue it, as it were, I have no right to go to the employment tribunal. That right only arises...
If there's detriment.
If there's detriment.
But if there is detriment...
Yes.
And there has been concern raised by Doug Stewart in the Employment Tribunal about people being put out of time. That was quite recently in the press.
Not what he said, Mum.
So. Well, can you...
Proceedings are ongoing at the moment.
Okay,
That's not what he said.
apologies. Okay.
Is part of the issue, I mean, I think what you said was just because I come and go and complain that the ladder's unsafe, that does not make me a whistleblower.
Well,
I mean,
you might be.
you might be, but that is at what point do you actually become the whistleblower? Once you've provided the evidence that
Well, you have to have provided the evidence, you have to, the information.
So until you've provided all of the information,
Not all of it, just enough.
Okay, and that's the complication, isn't it?
Yeah, whistleblowing legislation was created in the UK following the Herald of Free Enterprise. It's not European directive or anything like that. That actually came later. It's about significant matters being ignored and leading to disaster. That's how it started in that way. And you've got to frame that legally. So a criminal, and it protects people from raising those things against reprisal. Let's forget about the word detriment. It means reprisal. So when you draft it and you provide that it's a breach of any legal obligation, that could be the mutual duty of trust and confidence in my employment. It can be quite ephemeral things, if it meets the public interest, of course, now. So if every technician working on the reservoirs, when he asked a question about water sanitation or water safety, that we have to stop and get a panel in of independent people to say, well, is that a qualifying disclosure? I would say, Aaron, ridiculousness. You have to deal with matters that are raised through the course of, it's not just employment, the course of duties properly. So in dealing with matters, it must be those bodies, because presumably the best people to deal with water safety would be the utilities. They would know the rules or the regulations or the processes, and I don't think anyone coming in later could do anything in a tiniest way. Where the employee is complaining that I raised something honestly, I provided information, it wasn't just a complaint, it was a proper conveying of detail, and I've suffered for it, that inevitably is an employment relationship issue, whether it becomes a case or not. And I see that distinction. I think the policy endeavours to cover both. That there may be things that are so important we want someone to overview whether it's true. Well, I struggle to see how you delineate that, because you can't do it in every case. 99% are just things that happen every day. Is that the right prescription? Is that the right form to use? Have we done is that the right decision? Questions about that. It's complicated by the status of public sector employees, but I'm not sure that I think the policy creates confusion, that there's a belief that I raise a complaint, I take it under this policy, and some flying squad is going to come in and review everything.
If you don't review, nothing will get better, will it?
Sorry?
If there isn't a process in there of review, and certainly under the last whistleblowing committee, that what the expectation was, there would be recommendations, which was the review, and clearly we've heard very clearly this morning from the union that they don't feel any of the processes that have been implemented. And I'm saying that's just one view we've heard this morning, and I know you were present as well. However, we are still hearing of employees that are feeling that they are not treated appropriately once they've made a whistleblowing complaint, and they are continuing to suffer detriment. So the key thing that we need to establish is, where is it still going wrong?
Well,
as that's the perception.
You need to get beyond the perceptions to the examples of how people have been dealt with.
Yeah, and we've heard how people have been dealt with, but once they're in a process, there's very little information that the individual who's provided the whistleblowing complaint, they just seem to be, thank you very much, and they're only spoken to or dealt with once there's a next step. And we've heard during our committee evidence, people have whistleblown we believe it's been accepted as whistleblowing, and they still don't know the outcome 3 years later. And what we're trying, what everybody's trying to do.
Raising a matter rather than raising a complaint about how they've been dealt with.
No, it was raising a serious issue under the. It was raising an issue under the whistleblowing policy that they were advised to do by.
Yeah, but which type? A wrong is going on.
It doesn't. What we're trying to do here, the whole purpose of this committee is to make sure that the policy and process is being applied appropriately, the law's being applied appropriately, and at the minute we're not. We've heard various pieces of evidence, but what we need from the Attorney General's chamber is, and I think this is possibly the case, the advice that comes from you is coming too late. When you get involved, you then decide whether it's employment or whistleblowing again. No. Right.
Advice would be
tell you what, as soon as a new whistleblowing coming to you today from a department, a new complaint's come to you today, it's already been in the system of the department for 30 days, say. What happens once it reaches you in the Attorney General's?
Well, it depends what instructions have been sought, Mum.
So you wait for instruction from a department?
Of course.
So you'll only act on the department's instructions?
May only act, not just will, may only act.
Okay, so so that's really, really helpful, because the point of failure may be the direction and instruction you're getting.
We can't advise normally departments or any of the bodies about the manner in which they respond to a complaint, which is a matter they deal with within their expertise. How can I do that? I can advise about the law. The majority of advice will be taken at the point of complaint, a complaint that the employee or other worker believes they have suffered a detriment. I think you say the policy has to reflect the law. The law protects employees potentially if they have all the qualifications and complexity. If they believe they've suffered detriment, it can punish employers if they behave in that way. But it doesn't identify whether the DHA has responded to a query about how it's doing its work properly. That's not within the purview of the Employment Tribunal, and it's not within the governance of the Act.
Your experience with government departments and people providing instruction to you, do you see the same level of submission for that instruction coming from every area of government?
I do not have the level of experience to comment on between departments.
But actual whistleblowing itself doesn't necessarily have to. There doesn't necessarily have to be a detriment component to it.
For a claim, there does.
Under whistleblowing?
Yeah.
So if you report somebody for taking...
Are we talking about the Employment Equality and Employment Equality Tribunal here?
No, I'm just talking somebody comes, makes a protected disclosure that they are aware of somebody who's taking a bribe, for example.
Yes.
Okay. I suppose there's a that will pass the public interest test, but there's no. I mean, if I make that thing, it's no detriment to me. They're not bribing me. I'm not. Potentially as a taxpayer, I might be offended, but that's still a whistleblowing case, surely.
If made to a body which makes it a protected disclosure, yes.
Yes. Okay. So it doesn't necessarily involve detriment. So I mean, in other words, it would not be it's not an employment issue.
What gets you through the gate,
yes,
to come under the protection of the legislation, is to make a qualifying disclosure in a way that renders it a protected disclosure.
Yes.
Once you've done that, but that doesn't give you a cause of action, a right to take a case.
No.
Okay.
And I think that's a misunderstanding. It's a vein that runs through all of this. When people draft policies, they're trying to cover both fish and fowl. They're trying to cover both aspects of it, and the delineation of it, and the more you interpose responsibilities and processes, I think sometimes the more confusing it becomes who is doing what and who's responsible for what. And it is the case that people may not be aware of their legal rights, but of course it's very hard for the employer to how does that come about? People have rights and they choose not to pursue them. People have rights and don't know. People have rights, but believe they have rights, make claims and fail, or find that it's an unsatisfactory process. It's certainly not perfect on both sides. But you have to delineate the rights aspect away from the qualification aspect.
So under our remit, as I've said before, we're required to investigate and report on the impact of the government whistleblowing policy, and to include both the policy itself and the way in which it has been implemented.
Yes.
In your submission, you refer to prescribed persons outside a department, and you say the committee may wish to consider what it is the non-employer external body is expected to do and whether it has the powers to do this, especially in the context of the sort of disputes that can arise.
Yes.
Could you expand a little bit more on that?
Right. It goes back to the issue of what the policy... I mean, the policy was only... is dated October 25, I think it's right at the end of October. So I think in reality, there'll be very few, if any, matters have gone through that new iteration at all. So there's no, I don't have any database or experience to call upon. But in relation to what an individual reading this might feel happens, especially with prescribed persons, is I raise an issue. So I'm a member of I have to be registered by the SRA. If I refer somebody to the SRA or something, that has a role.
Sorry, do you want to
What's
just
the
explain?
SRA?
Solicitors Regulation Authority. That has a role. It is referred to in the...
Is that separate from Manx Bar? Are you
Yes, it is separate, yes.
separate from Manx
Yeah,
Bar?
but it just happens because, just an example, you could raise things to that body. A better one might be the NMC, that covers all nurses and midwives. But that has a role in relation to the regulated person. Some wider ones about education as well. It doesn't have a role reviewing the employer of that person. So if you refer somebody to the Manx, the Law Society, that is about their membership and individuals' membership of it. And I think when you read this, you've got to say, we've prescribed persons, quite rightly. If somebody refers, a manager finds out somebody's contacted a regulator and they're upset by it and they act inappropriately, absolutely that should be protected by the law, and that gets you through the gate, to use that euphemism again. You acquire the protection. But this policy, there's sometimes a belief that the regulator will, the prescribed person will come in, the flying squad analogy, and deal with things and review them. And you look at the list of prescribed persons, it's a very broad church indeed. It includes some departments in that way. So
It's not as broad as other jurisdictions, though, for the island. So with your experience that you've advised from the UK,
yes,
why would the Isle of Man not replicate that and put, for instance, Social Work England in it?
resources, and because many of the organisations you have at prescribed persons are actually not Manx organisations, they're external. Some of them don't have an express role over the Isle of Man. They regulate a profession, and Manx law says, for instance, to be a nurse in the Isle of Man, you have to be registered by the NMC. But the NMC is not a Manx organisation. Mm-hmm. So there are a number of reasons. I haven't looked at why particular prescribed persons were chosen. I'm sure they were chosen for good reasons, and the opportunities and whatever that apply. But I think what the point made in that comment was about the impression given to people looking at this policy or looking at the law that there are some powers for the prescribed person to act. There are, but they're limited by its own vires.
So could I just follow that on to the learned attorney? When the prescribed persons legislation was being revised, and we did add in after the Dr. Ranson case, the BMA, I think it was, and a couple of the other...
No, the BMA is not a prescribed person.
Well, GMC, apologies.
I believe GMC
Okay,
was on the list prior to that, but I may be wrong.
Okay, but we have added some additional ones into the prescribed persons list. Was that fully with consultation with yourselves for if a situation did arise on the island and you were then out having to defend a department against it?
I think your question is, were we consulted about expanding
it, yeah.
Category of prescribed persons, and I'll stand corrected, but I believe not.
Okay, thank you. Have any questions on?
I will check that, and if that's wrong, I'll inform the committee.
But our comment was more about the reflection of the policy referencing prescribed persons and the limitations of what they might do in relation to the question that was posed.
Okay, thank you. Obviously, under the remit of the policy, NDAs is always a topic that comes up, and I know we've had further commentary from you with regards to that. Do you think that NDAs could be overutilised by the employer?
As I refer to our submission, Mom, what is an NDA? It's a label that is applied, and we endeavoured to expand upon what that means. And I think it's already been alluded to, but an obligation of confidentiality in any agreement is not what certainly the UK organisations I quote would see as a non-disclosure agreement, because confidentiality is a necessary facet of many relationships and many agreements. If I've referred to again the SRA guidance, solicitors are required absolutely not to be party to non-disclosure agreements which are about concealing criminal actions, concealing that level of impropriety. But a compromise agreement or settlement agreement, they're interchangeable, but an agreement which concludes an employment relationship or concludes a claim or compromises claims in the employment tribunal has to meet certain requirements, and they are different on the Isle of Man. It's only that it goes via MERS, so it's a simpler process where the individual does not need to have legal advice, contrary to the position in the UK. The standard MERS agreement has a confidentiality clause. The agreement is confidential between the parties. That, on the face of it, does not say, and you can't, disclose any wrongdoing. Secondly, the standard wording, which I am familiar with on matters drafted by the AGC and certainly by me, expressly go further and say, for the avoidance of doubt, nothing in this agreement is to restrict your ability to, etc., disclose. The third thing, please, is Section 57 renders any provision that prevents somebody raising such things void. Not that it's an argument, void, ineffective. I think the questions raised and heard earlier are about perceptions. But that is about the engagement of those bringing about such agreements. And in the ones final point please, if I may, the ones I've dealt with express a clause specifically to do that, so there is no wrong impression.
So I think what I'm hearing from you is the agreements we've heard about today earlier by the union that are drawn up by MERS, they are not a document that comes out of the Attorney General's chambers. They're a document that MERS are using to process
That's what the law provides.
a settlement, but there's clear lack of understanding
I'm suggesting that that's what it appears. I don't know whether it's clear or not.
No, I'm talking from an individual that wishes, that's possibly been a whistleblower, but then they ended up with a compromise agreement via MERS. An awful lot of people say, I'm not allowed to talk about this. We've had representation saying, well, I can't come and talk.
I can't comment unless I was to see it.
So that's something that certainly needs reviewing them.
But I would say, I think it's in the thing, that many people reaching agreements which compromise employment or other relationships, individuals desire confidentiality. I've dealt with agreements where they said, well, the employer, there's nothing secret in this. We've got to report things, public accounts and what have you. Oh, we want a confidentiality agreement about the circumstances. So, and
they're all different. There's used to many different
I'm
things,
just
aren't they?
dealing with my experience to respond to that point. And compromise agreements are usually about people receiving deals in that way. So there are many other factors involved. Where usually, I think it says in the report, you're a long way away from I complained about an unsafe practice or an improper practice or whatever. It's usually about an employment that become overlain. And it may be that there's been wrongdoing in that, there may not have been. What there is a meeting of minds, that's what a compromise is, to conclude matters to the parties' apparent satisfaction.
That's good. Stuart Farrow explained earlier about the two different dimensions to the issue of whistleblowing, and I think you commented that the government's whistleblowing policy attempts to address both. It says if you're concerned about something, you can report it.
Yes.
This is what will happen. And it says if you're not satisfied with what's done about it, you can go to this additional stage. Do you think having a policy like that actually makes the issue of reprisals for whistleblowing worse? Do you think it exacerbates the risk that people will be subject to detriment or reprisal?
Can't comment on that. No idea of how people react in those circumstances. What I would say is if you were raising a complaint about the unsafe ferry you were driving on, you wouldn't fill a form in and send it for review. Some things have their own urgency.
Well, actually, I think really you've already answered my question, which was around non-disclosure agreements, and that's is there any involvement from the Attorney General's office in those, or are they drawn up and agreed between employer and employee?
We can. If we're instructed, we can.
On behalf of the employer or the employee?
Well, we're a government legal department, for want of a better phrase, so it can only be for government bodies.
Okay. So you could possibly have input or...
I have had.
Yeah. Okay.
On settlement agreements.
Okay.
But that won't serve to alter the law.
No.
So the section 164 point about should such an agreement purport to restrict the complainant, for want of a better description, from carrying on with the whistleblowing complaint, it is void, and it doesn't matter what the contract says. That's the case. And I heard Madam Chair say something about, well, people aren't being advised to that effect. And yet I heard earlier from our predecessor speaking that her members she arranges for legal representation of those members. Mm-hmm. So one wonders why they aren't being informed either by their legal representatives, by the union, or indeed by MERS. Mm. It's not something that can be laid at the door of the employer, I don't think.
Yeah, my comment was with regard to the MERS, really, and my comment was with regard to MERS and how they get involved in the process and what they get people to sign. Yeah, no, I know that, but the comment is with regards to what they get an individual to sign, because it was very clear they have a different contract or settlement agreement. Sounds like they've got a standard settlement agreement and they just fill in. Yes. No, I'm not saying that, but I'm just trying to establish the difference between a settlement agreement from MERS and and an undisclosure from the Attorney General's. That was the point of me.
Mom, there are no, can't emphasise enough, we do not draft non-disclosure agreements. We're not allowed to. They would be void and unlawful and regulatory breach.
So,
We have to be careful with this.
settlement agreements you have said you are involved with,
Yes.
but you just support how it's drafted, but you have nothing else to do. We need to understand this because it's clear what MERS do now. We need to understand if a department comes to you today and says, we need to get rid of an individual because where's your involvement? What do you produce? Legal advice. So who then draws that up? Individual departments?
You said the circumstance you speculated is about how to get rid of someone.
Well,
that's not necessary. Well,
sorry.
The question you asked, that's not something that would necessarily be amenable to legal advice. It may be improper.
So an employment matter that a department needs to resolve, and they seek the Attorney General's department's advice to deal with that. You give the advice, but they draw up the actual contract and agreement. So the PSC or individual department.
There are cases where they're dealt with by OHR or PSC as appropriate.
So OHR could be doing a lot of the...
we'll ask chambers to prepare a compromise agreement, which may include...
So they do ask you.
Confidentiality agreement,
on occasion.
which people describe as non-disclosure agreements.
Okay. Okay, that's fine. Thank you.
I think part of this terminology, I mean, I'm from a corporate high-tech backgrounds. We use NDAs, but that's for intellectual property and things as opposed
it's in my, I've referenced that in the paper. NDAs are a term of art in certain parts of the law.
Yes.
But they are not regarded as improper. They are improper if people are preventing raising criminal complaints and the like.
And I can't believe that MERS or any other competent attorney is going to draw up any form of settlement that's got an illegal, or tries to prohibit somebody from doing that. So I think, to some extent, this has become a bit of a red herring because, yes, I mean, settlement agreements, compromise agreements, NDAs, whatever you want to call them, are common everywhere and for all sorts of reasons, and a lot of them to do with financial disclosures and various other things which are largely irrelevant. But they cannot hide the fundamental basis of...
I think I agree with that. I think I would say that there appears to be a view that all compromise agreements are improper because they have a confidentiality aspect, and that simply that doesn't appreciate the circumstances or the nuance. And you have to remember, many settlements arise because the employee, the worker, makes that overture, whether directly or through unions or other agencies. So it's not about always, it's about a meeting of minds. The parties come to by the definition, most settlements are no pun intended, a compromise of both sides' views.
So a recent Tynwald written answer showed that compromise agreements had cost the Isle of Man near on £4.5 million in the last 5 years. Which is significant, but what percentage of that would have been a contract drawn up with the...
No idea.
You don't have any when I suppose what I'm trying to get to, we know the values each year, and that's been made very public. What we don't know is who decides the value of that. You would purely be involved in making sure the legal contract for whatever the situation is. You're not involved in the decision on the value.
It's not our decision to make.
You get an instruction.
Well, it's not our decision to make. We may give advice consequent to instructions about that, but the data you've referred to doesn't identify how much of those sums are actually legally were employment costs directly and how much might be an ex gratia payment. And there are matters within the financial regulations where decisions have to be made and approval sought in that way. We might be involved in such senses, but we are not necessarily involved in all or even the majority of settlement agreements.
Thank you.
One would just have to be careful about assuming that whatever the amount was, a couple of million pounds, is somehow referable to whistleblowing.
Yeah, no.
I mean,
It was compromise agreements, so it could be anything.
usually the provision for notice, for example, I'm sure the committee isn't making that assumption, but to assume that there's £2.5 million spent on shutting up whistleblowers, it was just so far.
No, I said compromise agreements. I didn't say.
Yes, well,
Yeah. So the final one for me, obviously our remit is the capability of the public bodies to address and resolve relevant failures. Our remit of the committee is we're looking at the capability of our public bodies to address and resolve relevant failures. So commenting on this, in your submission you say you cannot speculate as to what capabilities might be held at any particular time, but the relevant public bodies will tend to have that responsibility. If the relevant public body doesn't exercise its responsibility properly, what is an employee supposed to do?
well, they can complain further.
Two.
I mean, it's such a broad church. And I don't want to make it sound defensive, but a decision may have been made about the matter an employee raised or worker raised, and it may have been the right decision, but they're unhappy with it for whatever reason. They think it's wrong. Ultimately, someone needs to decide. So the point I make in that is that if it's the failing of criminal law, it's probably the easiest one, and you think, well, the employer's in breach of the criminal law, I've told them they haven't stopped, you go to the police. Or the finance aspects of particular requirements. If it's an environmental matter, there are people governing that. Some are quite obvious. If you think you are being placed into an unsafe working environment, there are things you can do through health and safety reps. It's so broad, Ron, it's impossible to prescribe. What the policies, I think, does is say, if you've got any of these issues, bring it to us and we will fix it. But that doesn't take away the right from the department, which has to decide whether that's safe or that meets the requirements. And all departments have political oversight. So if you say, well, who looks after that? That is the political oversight when it's raised in that way.
Okay. Any further questions?
No, just I think part of the problem is one of expectations. Expectations on the side of the employees, expectations on the side of politicians. I mean, we are dealing clearly with, there are some fairly black and white cases, but there's an awful lot that are, there's these grey areas, there's a lot of, we're dealing with some legal matters. And, as you've stated, the policy tries to do two things. And the question is, doing either one of them very well? And could it ever? I mean, that's my overriding concern. There's no easy answer to this because it is exceedingly complex, and I think we're looking for a silver bullet here, and I'm not sure there is one. There's a process, and a lot of people go through the process, don't feel satisfied, but again, is that a lack of understanding, a lack of due process, a lack of whatever? But that's where we're at. And but our remit here is to look at that policy and is it working? Now, you're absolutely correct. That latest policy of October 2025 or whenever it was, we can't because it hasn't been in thing long enough. But looking at the previous one, again, it's difficult.
I would final comment from you, perhaps. Turn things around. You're the manager receiving a complaint that something is improper, it's gone wrong, and you're trying to deal with that as best you can within your remits. Do you appreciate that could be a qualifying disclosure, or that because of your status it might be a protected disclosure? At your level, is that even possible? That the employment law is complicated. I don't think you can. People talk about training as a panacea, or more training will do, but this is one facet of employment law. And one observation about the policy is where it says that this policy cannot be used to raise individual or personal complaints about management decisions or concerns about individual treatment, including complaints of bullying, harassment and discrimination, I think they mean unlawful discrimination, affecting an individual. Well, that's a very broad statement about lots of other employment rights. I don't think that necessarily reflects the law, because issues of unlawful discrimination may well be matters of public policy. There's certainly matters of legal obligation, and there could be other aspects of the list as well. But expecting all managers to go back to their training about whistleblowing, I remember that, and to deal with it in that way. Tomorrow it's an issue about equality law. Next day it's an issue about parental leave, or qualifications for employment rights, or health and safety. It's a massive area. You cannot expect even senior managers to deal with a multitude of other things to have that immediate knowledge. And what you can look at are the resources they rely on and that are available to them. But I think you will come up against the bolster of saying we have not got the people, the time, the money or other resources necessary to provide that level of support at the scale of which you are dealing with things.
But following the case, the very big case that the Isle of Man's dealt with, Tynwald and the government have invested significant millions into the functionality of OHR and how they deal with this. And all we're hearing actually is that there hasn't been much change. So there has been the resources, there has been the money, and
well, I can't comment. I'm just saying, managing, that's where that resource will be at first hand, at least.
Sorry, I know you were trying to wind up, Chair, but there was one question while the gentlemen are here. I would really like to take advantage of and ask them to explain to me and to the committee a bit more. The thing about vicarious liability, so that was written into the Employment Act a couple of years ago as part of the recent changes. And I think
part of the evidence of the last committee.
It came out of the last committee. And I think I'm right in saying that the idea of this was that it would increase the incentive on the employer to not inflict detriment on people.
I saw that observation, yes.
Is that what... Is there a connection between vicarious liability and the incentive on them, people working in an employer, to get their act together and actually... Does it make any difference, I suppose, is my question.
The ill it was intended to address and did address was the possibility of a respondent in a claim saying, we didn't do that, it was done by an employee in an authorised fashion, and therefore we're not liable.
So blaming the middle management, effectively?
Well, blaming the individual. It could be a very lowly colleague. It could be somebody who's your subordinate. It doesn't have to be a manager who submits the detriment. But it avoided that lacuna where people say, okay, get out of that. Whether that has encouraged better training and awareness, as I say, it's not just a resources issue on the scale of the Isle of Man, it's a resources issue anywhere, in any public sector or private sector. Do you train all your employees not to be nasty people in relation to whistleblowing, equality, terms and conditions, the way they deal with people at work, and the list could go on. And the answer is you probably don't. What you do is you have a structure which allows for those to be dealt with in that way and relies upon the resources available when those matters come up.
So-
I think you are looking at a panacea if you're trying to stop, it's been mentioned already this morning, earlier, human nature taking its course.
So another area that comes up briefly is equality of arms. Many of the individuals that have taken on a full whistleblowing situation feel that there's no equality of arms and that the departments have, I think you called the might of the Attorney Generals behind them.
Yes, it's been described as limitless resources. I would like to know where they are.
But again, it's perception, and individuals are feeling that way. What costs do you cross-charge back to departments for your services? You don't.
No.
So nobody actually knows the true cost of a full employment situation, do they?
We've been asked that question in different ways before. Chambers does not cross-charge its clients, but of course our lawyers record their time. So
Okay.
in my exchange most recently with your clerk, I wasn't quite sure of the context of your question as to what compromise agreements cost, and one of the answers I imagined was how many hours our lawyers spend. But I realise now that wasn't really the question. But the way we value our services is that we do keep time records, and have long done.
Okay. Any more questions? Anything else? No. Thank you very much. I will close this session now to the public, and we'll sit in private. Thank you.